Calling the meeting to order. Roll call, please.
Here.
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 Here. Thank you. Chair Fuste asks that the following is noted in the record regarding his absence. I'm unable to attend today's meeting due to a scheduling conflict. While remote attendance has not been authorized by board policy, I recognize that attendance remains each member's personal responsibility. Commissioner Lyle asks that the following be placed on the record regarding his absence. If the commission would allow my participation remotely, I could attend the meeting at least up till 12:30. However, because the commission does not allow commissioners to participate remotely, I will not be at the upcoming meeting this month. Please rise for the pledge. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. I have some housekeeping announcements. The First District Court of Appeals graciously lets us use their facilities, so please respect their rules. No food or beverages other than water in this room, please. Please silence your cell phones. We have received some feedback from the public that sometimes it's difficult to hear members and those before the commission, both in the room and over live stream. Anyone addressing the commission, please be sure to speak up and speak into the long microphone at the podium so you can be heard and so our broadcast audio and recording equipment can pick up your comments. To my fellow commission members, please speak into the long microphones on the dais so your comments and debate can be heard. If you share a microphone with another member, please pull it as close as possible to you when speaking. Members, I ask that you be as brief and concise as possible in your questions and comments as we have a number of items for consideration today. Pursuant to Section 286.0114 Florida statutes, members of the public have the opportunity to have input on matters before the commission other than in cases in which we act in a quasi-judicial capacity. This means the public can have input on matters other than complaints, opinions, and determinations in financial disclosure cases. If you desire to be heard on this matter, please fill out a speaker card and give it to Ms. Fulford, who has her hand up. Okay, first up on the agenda is approval of minutes. Has everybody had a chance to look at the minutes? And if so, can I get a motion?
Make a motion to receive the minutes.
Second.
All in favor?
Aye.
Aye. Any opposed? Do I need to be on the record saying motion passes? Motion, does it help? Okay, motion passes. Continuance announcement. Item 4 on today's agenda, complaint number 20-060, 20-073, and 2103 consolidated in reference to Randy Fine were continued by Chair Fuste. Chair Fuste also continued item 13 to afford members who were not present during the commission's previous discussion about remote meetings an opportunity to have input. Okay, our first item, it looks, let me take this off. Okay, our first item up is item 4, consideration of final action. 2, 3, 4, 1DCA mandate. Sorry, I was just looking at it. It's my first time chairing, so I'm trying to read the stuff and read your statements at the same time. This is a consideration of adoption of a final order and public report upon mandate of the District Court of Appeal. Before we ask staff to explain this matter, are Mr. Underhill or his counsel in attendance?
Mark Hammer on behalf of Doug Underhill.
Are there any members who need to make a disclosure in this matter? Okay. Mr. Schaefer, you are recognized to explain the posture of the matter before us.
Thank you, Madam Chair. As you can see in your meeting materials, this matter concerns entering a final order on 3 consolidated complaints following an appeal to the First District. And as you can see in your materials, the first DCA has ordered the Commission to set aside its initial final order in this matter, which was the order on appeal, and to adopt in its entirety the recommended order by the Administrative Law Judge. The Commission really does not have any jurisdiction here. The appellate court has given us clear instructions that the ALJ's recommended order be adopted in full, and that will close the case. Now, Steve went over the background of this appeal at our last commission meeting, but just to refresh your memory, these 3 complaints were filed against Douglas Underhill, who at the time was a member of the Escambia County Commission. There are several grounds alleged in the complaints, but following a full evidentiary hearing at DOA, the ALJ recommended the Commission find only 3 violations of the state gift law. First, that the Commissioner violated the gift law by accepting a gift to his legal defense fund of more than $100 from a county vendor or lobbyist. Second, that the Commissioner violated the gift law by failing to report a separate gift to his legal defense fund of over $100. He did not report that. The ALJ recommended finding on his Form 9 gift disclosure. And third, the Commissioner separately violated the gift law by failing to report on a Form 9 a gift of free legal services from a law firm. Now, I will say regarding the 2 allegations about the gift law violations about the legal defense fund, the appellant actually conceded at DOA that he had committed those violations. Now, for these 3 offenses, the ALJ recommended the Commissioner be issued a public censure and reprimand, and in addition, regarding the allegation that he did not report the gift of legal services, that he be issued a civil penalty of $5,000. Now, the Ethics Commission, when it received the recommended order, accepted the recommendations on those 3 violations I just listed, but it went on to modify some other legal conclusions concerning other allegations, and it increased the penalty for all the offenses. And it was those actions that the Commission took that were the subject of the appeal to the District Court. And for the reasons you can see in the appellate opinion in your materials, the DCA disagreed with the Commission's reasoning, and it remanded the matter to us with instructions to set aside the initial final order and adopt the ALJ's recommended order in full. So the order in front of you simply follows the DCA's instructions. It accepts the fact findings and legal conclusions made by the ALJ and concludes the appellant has committed 3 different violations of the gift law as I just described. For those offenses, the order adopts the ALJ's recommendation of a public censure and reprimand and imposes the additional penalty of a $5,000 fine for the violation related to the failure to report the gift of legal services. I submit this order to you now. I'm happy to answer your questions.
Are there any questions from the commissioners for Mr. Schaefer? Thank you, Mr. Schaefer. Presentation from respondent or counsel?
Madam Chair, members of the Commission, I will be very brief. Mr. Schaefer has clearly and accurately pointed out what the Commission needs to do this morning, and we would urge the Commission to adopt the first DCA's mandated ruling and enter the final order as directed. Thank you.
Thank you, sir. Any discussion? If not, then if someone could make a motion.
To adopt the draft order.
Second.
All in favor?
Aye.
Any opposed? Motion passes. Thank you, gentlemen. Item 5, consideration of final action, joint stipulation. The next 3 items for our consideration today relate to complaints where probable cause was found in a previous meeting of the commission, and we now have before us a proposed joint stipulation between the commission advocate and the respondent. After considering all the materials and the presentations of the parties, the commission may vote to approve or reject a stipulation. If a stipulation is rejected, the parties cannot renegotiate and present a new stipulation at this meeting. The complaint would go to the Division of Administrative Hearing for an evidentiary hearing, or the parties could negotiate a new settlement for consideration at another commission meeting. We'll now take up the amended stipulation in complaint 23-283, Angela McDonald.
May I proceed?
Sorry. Again, I got to read that, and then I want to get it open to look at it too, and so I'm slower than your well-trained chairs. Okay. It says complainants have the right to respond in writing to a stipulation. We do not receive a response. We did not receive a response from the complainant in this case. Are there any members of the commission who need to make a disclosure regarding this case? Ms. Hadley, you are now recognized at this time.
Okay. Respondent was appointed to the Boca Raton Housing Authority Board of Commissioners. The commission found probable cause to believe she violated Section 112.31483 by soliciting a gift from a prohibited donor, and Section 112.31488 by failing to disclose the receipt of a gift that exceeded a value of $100. The parties entered into a stipulation regarding both matters. However, after the probable cause hearing and signing of the original stipulation, the First District Court of Appeal issued a decision reversing the commission's interpretation of solicitation. In light of this new guidance, the evidence does not reflect a violation of Section 112.31483. As such, the parties present to you an amended stipulation. In the stipulation, respondent admits that she violated Section 112.31488 and agrees to the entry of a final order recommending a civil penalty of $500 with public censure and reprimand. And we request a dismissal of the allegation regarding Section 112.31483. We respectfully ask for the commission's approval of the joint stipulation.
Thank you. Questions from the members of the commission? Respondent or counsel present? Since there's no questions, I mean, this is now our time to discuss or debate. Does anybody have any comments from the commission?
To adopt the amended joint stipulation.
Second.
Thank you. There's a motion to adopt the recommendation for the joint stipulation. All in favor?
Aye.
Any opposed? Motion passes. Item 5B, consideration of final action joint stipulation. The next stipulation up for consideration is 24-008 in reference to Kenneth Brenner. Will the parties or their counsel please identify themselves for the record? The complainant did not file a written response to the stipulation. Are there any members of the commission who need to make a disclosure regarding this case? Mr. Burns, you're now recognized to present the stipulation.
Thank you. The complaint in this case alleged that respondent filed several inaccurate financial forms with the commission, including Form 1s for the years 2019 through 2022, as well as a Form 6 from 2023. At the commission's October of 2024 meeting, probable cause was only found regarding the 2023 Form 6. Respondent has already filed an amended Form 6 providing the public with the information of which it was deprived. Accordingly, the stipulation recommends a civil penalty of $250.
Questions from the members?
Motion to adopt the joint stipulation.
Second.
Motion to adopt the stipulation. All in favor?
Aye.
Yeah, me second. Any opposed? Motion passes. Thank you, sir. Item 5C, consideration of final action joint stipulation. The next item is consideration of the amended stipulation complaint number 24-048 in reference to Ron Mueller. Will the parties or their counsel identify themselves for the record? We did not receive response to the stipulation from the complainant in the case. Are there any members of the commission that need to make a disclosure in this matter? Ms. Hadley, you're now recognized to present the stipulation.
Respondent served on the Winter Garden City Commission. The commission found probable cause to believe that he violated Section 112.31483 by soliciting a gift from a prohibited donor, and Section 112.31488 by failing to disclose the receipt of a gift that exceeds the value of $100. The parties did enter into a stipulation. However, after the probable cause hearing and the signing of the original stipulation, As noted earlier, the first DCA issued a decision reversing the Commission's interpretation of solicitation. As such, there is no evidence of a violation of Section 112.3483. We present to you an amended stipulation. In the stipulation, respondent admits he violated Section 112.31488 and agrees to the entry of a final order recommending a civil penalty of $250 with public censure and reprimand, and requested dismissal of the allegation regarding Section 112.31483. We respectfully ask for the Commission's approval of the joint stipulation.
Thank you. Any questions from the commission?
No more.
No questions?
Need a
Take a motion, yes.
I move that we receive the joint stipulation
Accepted.
as stated.
Anybody second?
Second.
All in favor?
Aye.
Any opposed? Motion passes. Thank you, Ms. Hadley. Item 6, complaint number 22-079 in reference to Randall Fine. Consideration for this matter has been continued. Item 7, consideration for legal sufficiency. Complaint number 25-047 in reference to Joanne Alvarez. This is a staff recommendation of legal insufficiency of a complaint wherein the respondent has waived confidentiality. Commission rules do not permit participation, excuse me. Commission rules do not permit participation by the respondent or complainant at this stage of the complaint process. Members, you have the written staff recommendation in your materials. Before we consider legal sufficiency of this complaint, are there any members who have disclosures we need to put on record? Are there any members who have questions about the draft or who wish to have staff present the draft order? Do I hear a motion to adopt the public report and order dismissing the complaint? Is there a second?
Second.
Okay, all in favor?
Aye.
Aye. Any opposed? Motion passes. Item 8, consideration of advisory opinions, file 2818. The next agenda item is a consideration of advisory opinion, file 2818. Any public officer, candidate for public office, or public employee in Florida who is in doubt about the applicability of the disclosure laws or standards of conduct to himself or herself, or anyone who has the power to hire or terminate another public employee, may seek an advisory opinion from the commission about himself, herself, or that employee. Advisory opinions are based solely on the facts provided by the requester and are legally binding on the conduct at issue. Is there a requester in attendance? Mr. Schaefer, if you will present the draft opinion, please.
Thank you, Madam Chair. This opinion request comes from the Assistant County Attorney for Miami-Dade County. He's bringing the request on behalf of a county commissioner. The commissioner is thinking about sponsoring legislation at the county level that will create a brand-new business entity. The entity's sole purpose will be to assist the county in public and affordable housing matters. Now, just by way of background, Miami-Dade County is considered to be a public housing agency. From what we've been told, that means the county owns public housing properties and oversees the development of those properties. And in the past, the county has contracted with outside private developers to assist it in applying for funding related to this public housing. Now, the process of applying for public housing funds and really public housing in general are matters outside the scope of the Code of Ethics. So we're perhaps not the most, we don't have the best expertise regarding that. But I believe that means that private developers partner with the county on applying for funding from government agencies that the county couldn't otherwise apply for on its own. Now, the process of partnering with private developers, though, is costly, and the county commissioners here are looking for more economical ways in which the county can develop its remaining public housing, as well as develop its affordable housing projects without needing to use the private sector. And as I said, the commissioner's idea is to have the county create a business entity that will function solely to assist the county in its public and affordable housing developments, including applying for this government funding that in the past would have been applied for by private entities. Now, the county commissioner doesn't know yet exactly how this entity will be structured, whether it will be set up as a nonprofit or some type of LLC. but it's been indicated to us that no matter how it's structured, the following things would be true. First, the entity would be wholly owned by the county. Second, the county commissioners, as part of their official duties, would serve as the entity's board of directors. The requester stated that they would be considered an integral part of their responsibilities as county commissioners to serve as the entity's directors. Third, the commissioners' service as these directors would be unpaid, and there would be no change to their public salaries. And fourth, county employees would be performing work for the business entity through some type of shared use agreement. This agreement would be between the county and the entity. It would expand the job responsibilities of certain county employees, particularly employees in the housing department, to perform the daily work required by the business entity. So in other words, the entity itself would have no actual employees. This work would be performed by county employees on loan to it through this shared use agreement. Now, we've been told the employees did not receive any compensation from the business entity. They'd be paid only by the county, and they would be considered salaried W-2 employees of the county alone. So that's the background, and we've been asked if there's any ethics issues for the county commissioners or county employees if the business entity is set up in the manner I just described. Meaning, again, the county would wholly own it. County commissioners would serve as unpaid members of its board of directors, and its work would be performed by county employees through this shared use agreement. I think it's important to note, first of all, that the Ethics Commission's analysis here is somewhat limited. We're only looking at one piece of a very large puzzle. The Commission has no jurisdiction to address whether or not the county even has the authority to set up this business entity, or whether the entity will be able to apply for housing funds. That would hinge on state and federal housing laws the Commission has no authority to interpret or opine on, and it'll be up to the county to reach a determination regarding those questions. Our piece of the puzzle is purely whether, if this entity is set up in the manner that I described, whether it would trigger a violation of any of our ethics prohibitions for the county officers and county employees that would be affiliated with it. So if you look at the draft opinion, question number 1 analyzes this in the context of the county commissioners, whether it would present any conflicts of interest for them if they were to serve as unpaid directors of the entity. And question number 2 analyzes in the context of county employees who would be performing work for the entity through the shared use agreement. So looking first at question 1, I think it's important to note the county would be purchasing services from this entity. The county budget would be setting aside money that would be used to fund the entity. So essentially the county would be paying the business entity for its assistance in public and affordable housing matters. And that would technically trigger a violation of Section 112.313, subsection 3 for the county commissioners. Now, 112.313, subsection 3 is triggered when a public officer serves as an officer or director of a business entity that's selling services to their own agency. And here, the county commissioners, as I said, would be serving as officers of this nonprofit, and the nonprofit would be doing business with the county, whether it's a nonprofit, an LLC, or however else it's structured. But the commission in the past has found a technical conflict under Section 112.313, subsection 3, can be negated if there's a unity of interest between the outside business entity and the agency. This is usually found when there's 2 factors present. First, when there's organizational alignment between the outside entity and the agency, such as when the agency can appoint members of the entity's board of directors. And secondly, when that's coupled with an actual practical alignment of interests, when the entity and the agency are moving in lockstep towards a common goal. Now, our recommendation here is that while there might technically be a conflict under Section 112.313, subsection 3, for the county commissioners to serve as the entity's directors, that would be negated because there appears to be a unity of interest between the entity and the county. First of all, there would seem to be organizational alignment. The county will be creating the entity. It would have sole ownership of the entity. County commissioners would be serving as the entity's directors, and county employees would be performing the entity's work. So that component of organizational alignment would seem to be present. Also, there would seem to be an actual alignment of interest because we've been told the entity's sole purpose will be to assist the county in its public and affordable housing responsibilities. So given the close alignment here between the county and the business entity, it seems the unity of interest consideration would cure any violation of Section 112.313, subsection 3, if county commissioners were to serve on the entity's board. Now, there's a couple other statutes that are discussed in question 1 of the draft regarding county commissioners. Those other statutes are Section 112.313, subsection 7A, and the voting conflict law. Now, 3137A concerns having a conflicting outside employment or contractual relationship. But the Commission has consistently found in the past that serving as an unpaid director does not constitute the type of employment or contractual relationship that will trigger the statute. And that's what would be happening here. The county commissioners would be serving as the entity's directors, but they would be unpaid for that service. And if you look at the voting conflict law, that also doesn't seem to apply. The voting conflict law is violated if you're voting on a measure that will financially benefit a principal who retains you, like an employer. But as I said, the commissioners here won't be paid for their services to the business entity. So it doesn't appear they'll have that principal type of relationship that could trigger a voting conflict. So long story short, we've looked at our different statutes here, and it's our recommendation that the commissioners will not have a prohibited conflict under them if the business entity is set up in the manner that's been described to us and they're serving as unpaid directors. That's question 1 of the draft. Question 2 looks at county employees. The only relevant statute for them would be Section 112.313, subsection 7A. Now again, that law requires a conflicting employment or contractual relationship. Now, the requesters have been clear to us here that even though county employees may be performing work for the business entity, they won't be paid by the entity. So they won't be considered W-2 employees of it. They will just have an employment relationship with the county alone. And they also will have no personal contracts with the business entity. They'll be performing work through that shared use agreement where the county will be allowing them then to perform work for the entity. So it just doesn't seem here that they will have an employment or contractual relationship with the business entity, which you would need to trigger our statute. Essentially, that shared use agreement will just be expanding the scope of their county employment. They'll be performing duties for the business entity, but those duties will just be considered part of their public job responsibilities, and they will be remaining only county employees. So again, they won't have the outside employment or contractual relationship that you'd need to trigger the statute. I know this has been a long presentation. I want to thank you for your attention. I offer this draft now for consideration. I'm happy to answer your questions.
Thank you. Any questions? You recognized? It's the long mic. This mic. The long,
Yes.
that one.
Okay, sure. So this was brought by the Miami-Dade County?
This is brought by a Miami-Dade County Commissioner, and the actual individual who brought it was one of the assistant county attorneys bringing it on her behalf.
And your interpretation then, though, would apply to any county that may decide to go in this direction once they solve the other issues?
No, Commissioner, this would just be applicable to these particular circumstances. This would just apply to this particular scenario that's been raised to us.
Other counties who may be interested in a similar arrangement then would have to go through the same process?
I would encourage them if they were to call in, even though this opinion is out there, and if you approve it, we could perhaps rely on it for guidance. They would still have to bring the question to us. This would just be binding on the actual party bringing the request here.
Thank you, that's my question.
Any more questions?
So on the first issue, the unity of interest,
Yes.
so that analysis applies just to subsection 313, sub 3, doing business with
Can you get
one's-
closer to the microphone?
doing business with one's own agency. Does that unity of interest apply only to that, or is that?
That's a great question. You're asking if that would apply to any other statutes as well that we're
Correct.
discussing? Yeah, the unity of interest consideration is a mechanism that the Commission has used to negate a conflict under Section 112.313, subsection 3. It also can be used to negate a conflict under the first part of Section 112.313, subsection 7A, which is a statute they talked about having an outside employment or contractual relationship that could conflict with your public duties. But here, it doesn't appear that serving as unpaid directors will even create the type of employment and contractual relationship for these commissioners that would even require further analysis of the statute.
So we don't have to reach that.
Right.
question.
If they were being paid by the entity, then I think we would have to then reach, applying the statute on the merits, and our recommendation would probably be that the unity of interest would cure any technical violation under the first part of the statute.
And the unity of interest, we'll call it exception, that's founded on, like, the statutory basis for applying that comes from 112.316?
Yes, ma'am.
Okay. And it makes a lot of sense, and I totally agree with the analysis, and appreciate the presentation. I guess now that I understand sort of the framework, I guess the question I have is, I guess what triggered the analysis here? Because I don't recall, at least in my very, relatively short tenure, ever going through this analysis on an individual case basis. So here, we're in the advisory opinion context, but when we're talking about actual cases to determine whether or not someone's violated the law, I don't really remember ever having a robust discussion about whether we go through this unity of interest analysis. So is there something particular that triggered it here where it's not ordinarily triggered in other circumstances?
Sure. Well, I mean, I would think that there might be several different answers to your question. First of all, I will say, as you can see in the draft in front of you, the unity of interest is a consideration that does come up from time to time in the context of advisory opinions. Usually, we're not going to give somebody advice over the phone or by letter about the unity of interest because it does hinge on that statute 112.316. It's a more technical question that I think often we would bring before the commission. And that's why you're probably going to see it come up more often in advisory opinions than in complaint proceedings. Now, it can apply in complaint proceedings, though. Usually, I would think that there's several other different steps to the analysis we would look to first. We'd look again to make sure there's an employment and contractual relationship under 112.313 subsection 7 before we would turn to 112.316. There's also those exemptions in 112.313 subsection 12, the statutory exemptions that would be applicable to the statutes that we're discussing today. So one of the reasons why you may not have seen in the context of a complaint proceeding is that in the past, other exemptions kind of got us where we needed to go without needing to look to the unity of interest consideration.
Okay. So I guess the fact that this is a county creating, it's a unique factual circumstance. So that's sort of why we ended up at this exception.
Yes.
Because normally, I guess, other off-ramps are available before.
Yes,
Okay.
and again, this is something unique. The county is creating a business entity to assist it, so that's not exactly a run-of-the-mill question.
Right.
And so after discussion with Steve, and we decided that we would suit this up as a formal opinion instead.
Okay, great. And I apologize. I didn't go through through any of those follow-up questions. So sorry. I apologize.
The chair didn't know that was her job,
Okay.
the chair's clueless about it.
Okay, and thank you for tolerating my questions. Oh.
And just to co-sign everything that Grace said, as a matter of procedure, when we do get a opinion request, usually they want advice over the phone or by letter, but when we think that the question resolves through the unity of interest application of 112.316, we're pretty much always going to bring that in front of you. We're not comfortable at the staff level making the declaration that they're going to be, that application of 112.316 applies. That's really a question that we would rather the board resolve. So when we think that that's the matter, we're going to bring that in an opinion request.
Are there any more questions? I have I guess, clarification / question. It says county commissioners and employees. Is this set up in a way that all the county commissioners will be the board of directors of this entity, and then when they get reelected, the new one just takes the spot? Or does that county, that's what I want, that's what I'm curious about.
That's a great question. The way that it's been described to us in the initial written inquiry is that the county commission will be serving as the entity's board of directors.
Regardless of who's on there. So they don't take that title with them, and now they're a lay person who's also on this board in the future.
The way that I would read that is that once they leave the county commission, whoever replaces them will take their place on the board.
Okay. Thank you. Any other questions? Okay, I'll entertain a motion.
Moved.
Anyone like to second?
Second.
Ms. Lucas, second? Was that a second?
Yes.
You guys are so quiet
I-
today. It's like a,
Trying to read.
Lot to read.
Sorry.
oh, do you have a question?
Well, you already got the motion now, but
Well, we can still discuss. We've got a second on the table. We can open for
Okay,
discussion
so-
before we vote.
I heard you in your beginning statement indicated that as long as the commissioners are not compensated, then it's all right that they can serve on the board. Is that correct?
We don't feel that would create an issue under our statutes, assuming they're unpaid.
Well, statute 112, I think is 7, let me, what's that statute? Give me a minute, let me get to it. One 337, what's that statute? Anyway, let me just say that, so what you were saying is that if they are involved and they're on the board and they are not compensated, they still can engage as long as they are not under contractual agreement.
You're talking about county commissioners serving on the board or county employees performing work
The
for the
county
entity?
commissioners.
The county commissioners,
Okay.
right. Go ahead.
Okay, great, I'm sorry.
No, our understanding and the way that we drafted this opinion is just what we were told, is that they would be unpaid directors and they would have no contractual relationship with it either. And our past opinions have been very clear that if you're an unpaid director of a business entity or of a nonprofit, it doesn't create the type of employment, a contractual relationship that would trigger the statute. Now, I will add, Commissioner Lucas asked, what happens, does the unit of interest consideration, can that even be applied to other statutes? Now, if they were being paid, as I told Commissioner Lucas, we would probably recommending applying the unit of interest consideration to cure the conflict under Section 112.313, subsection 7A. So, I'm not sure that the analysis under that particular statute would have a different result, even if they were being paid.
Okay, that's where my concern was at statute 112.31378. And so I thought I heard you said earlier that they could not, based on the statute itself. And then you say they can if it's a business type of relationship. So are you saying they are clear, they are not violating that statute 112.31378? If they are on the board?
Yes, and let me qualify that. If they're not being paid, which is what has been explained to us, the analysis that's in this draft opinion in front of you would be applicable. Now, if they were being paid, though, and that is not the facts that have been presented to us, if they were being paid, they would technically then have an employment relationship with the business entity doing business with the county, with their agency. That would technically trigger the first part of 112.313 subsection 7A. But as I explained to Commissioner Lucas, the unit of interest consideration that we're using in the draft for a different statute, that unit of interest consideration could then be applicable to 112.313 subsection 7A. And so the conflict would still likely be negated even if they were being paid. We would get to the same result just through a different path.
Okay, well, sound like the statute are giving the very antithesis. You're saying they can't, but then again, they say they can. So I got my answer. Excuse me, I got my answer.
I have one more question before we vote. The board of director meetings for the new entity, are those public meetings?
That I don't know the answer to. Again, the entity hasn't been set up yet. They're just asking this preemptively, and so I'm not sure how they would structure that. And that would also depend on, I suppose, the application of the open meetings laws that we don't have any authority to interpret.
Yeah, I think that's a concern for me because, for example, my days on the school board, we had an entity that school board members were part of, a leasing corporation that we had to meet annually. And we actually would adjourn a school board meeting and go into the leasing corporation meeting, vote on what we had to publicly because we're public officials under sunshine law. And so if they're forming this entity that's going to meet as a board of directors of a nonprofit, do they now go in the shade to meet to make decisions? And then they can make all kinds of decisions as a board of directors that could benefit them as county commissioners, and that's not done in the public. So I think that's concerning.
Chair, those would be statutes, though, outside the jurisdiction of the Code of Ethics. We don't have any authority to write an opinion or offer any recommendations regarding the Sunshine Law. So certainly that's something that the county will have to work through and look into, but it's not something that would be directly under our authority to opine on.
I may have no authority, but I'm just going to put it in the record that they should hold those meetings in the public, in the sunshine. Any more discussion or questions before we vote? We have a motion to accept and a second on the table. Would anybody, we'll take a vote. All in favor?
Yes.
Aye.
Any opposed? Motion passes with Commissioner Bush in opposition. Thank you. Okay, we are now on item 9, consideration of executive branch lobbying firm fine appeal. Appeal number L22-001 in reference to Keystone Golden State Strategies Incorporated. Item 9 on the agenda consists of the appeal of automatic fines under the executive branch lobbyist registration laws. The appeal seeks a waiver of automatic fines for late quarterly compensation reports required to be filed on a quarterly basis by executive branch lobbying firms. Pursuant to Section 112.32155D, which assesses an automatic fine of $50 per day on a lobbying firm that fails to timely file an executive branch compensation report, the Commission may waive the fine in whole or in part for good cause shown based on unusual circumstances surrounding the failure to file by the designated due date. The maximum fine that can be assessed in each quarter is $5,000. The appellant did request a hearing in this appeal. Before I recognize staff to present the draft order, is anyone from Keystone Golden State Strategies in attendance? Do any members need to make a disclosure on the commission? Mr. Schaefer, you're up again to present the draft order.
Thank you, Madam Chair. Just one clarification. This lobbying firm is the Policy Standard LLC. We don't receive many of these kind of appeals, Commissioners. This is the first we received in almost 2 years. This happens when an executive branch lobbying firm fails to file in a timely fashion a quarterly compensation report. If you are a lobbying firm and you employ a registered executive branch lobbyist, you have to file a report each calendar quarter indicating the range of compensation you receive from each of your clients. There is a deadline for those reports. They're due 45 days after the close of each calendar quarter. Now, for each day that a firm is tardy in filing a report, they accrue a fine of $50 a day, up to a maximum of $5,000 for each late report. And once the Ethics Commission tabulates the final total of the fine that's assessed, it must give the firm 30 days to appeal before the fine will be imposed. And that's exactly what happened here. As I said, the firm is the Policy Standard LLC. They're appealing a fine related to their failure to timely file a compensation report for the fourth quarter of last year. That report was due on Valentine's Day, February 14, 2025. But the firm did not file it until 31 days later, on March 17th. So they accrued a fine of $50 a day. They were 31 days late. So their fine eventually totaled $1,550, and they've now brought a timely appeal regarding that fine. Now, appeals in these kind of fines, and the chair already mentioned this, where a lobbying firm has not timely filed a comp report, the firm has to demonstrate an unusual circumstance that caused them to untimely file. The rule defining that term says it means an uncommon, rare, or sudden event over which the firm had no control and which resulted in their failure to timely file. It's actually the same standard that we use when you're assessing financial disclosure appeals, when filers don't timely file a Form 1 or a Form 6. Now, for the reasons given in the draft order in front of you, I'd recommend here that you do not find unusual circumstances and that you affirm the fine. The firm is claiming its failure to timely file the report was because it had, quote, inadvertently overlooked the requirement to file the report because it was closing its lobbying operations prior to the fourth quarter of last year. I will say the fourth quarter report, which they did ultimately file, does reflect that they earned no executive lobbying compensation during the fourth quarter period. But the fact that they may not have conducted any executive branch lobbying or earned any compensation during the fourth quarter is not a valid basis to waive the fine. I want to make that very clear. The statute requires that if you're a firm and if you employ a registered executive branch lobbyist, you need to timely file your quarterly comp report, even if it's just to report $0 in compensation. And the statute actually says that. It says you have to file the report even if just to show $0. Now, the firm's exact reason here seems to be that they were closing their lobbying operations, and due to that process, the requirement to timely file the fourth quarter report was just overlooked. Now, that's an understandable reason. It may have even been unintentional. But it still does not seem to constitute the type of unusual circumstance that would justify waiving the fine. That's a really high burden to clear. Inadvertently overlooking a filing requirement is not an uncommon, rare, or sudden event that would have prevented them from timely filing. Also, please keep in mind that the firm received notice prior to the filing deadline of their need to file that fourth quarter report. Commission records indicate that the Commission sent an email on January 1st of this year, right after the close of the fourth quarter, indicating their need to file the report, letting them know the deadline, and letting them know that fines would accrue if that form was not timely filed. And OLITS has confirmed for us that that email was successfully delivered. I think it's also important to note that this same firm just received a waiver of their failure to timely file their third quarter comp report for last year. Each lobbying firm under the law gets a one-time waiver of an untimely filing of a comp report. This same firm received that one-time waiver regarding their third quarter report from last year, which is immediately prior to the fourth quarter that we hear about today. So given the fact they received notice, given the fact that they just got a waiver of their third quarter report, it seems they should have been aware of their filing obligation. So drawing all this together, our recommendation is you do not find that inadvertently overlooking a filing requirement is the type of unusual circumstance that would justify waiving the fine. So our recommendation is you do affirm the fine of $1,550. The draft order reflects that. I present it now to you, and I'm happy to answer your questions.
Thank you, Mr. Schaefer. Are there any questions from the commission for Mr. Schaefer?
So this firm is still in business?
My understanding is that the firm is still operating, but they do not have currently any registered executive branch lobbyists, so it doesn't appear they're lobbying the executive branch.
Any more questions from the commissioners? Nope. We're ready for a motion. I just want to clarify, the entity is the policy standard. I misstated who they were when I was reading the statement. Is there a motion?
Motion to adopt the proposed final order.
Is there a second?
Second.
There's a motion. There's a second by Mr. Figurs. All in favor? Aye.
Aye.
Any opposed? Motion passes unanimously. Item 10, consideration of financial disclosure appeals. Hearing requested, FD 21-028 in reference to Ben King. This is the consideration of an appeal of the automatic fine assessed for the failure of Mr. Ben King to timely file the annual financial disclosure form. Is the appellant or counsel in attendance? No. Are there any members who need to make a disclosure? Okay, Miss Novanario.
Hello, I'm Stephanie Novanario. Thank you, Madam Chair. Appellant in this appeal is Mr. Ben King. He was an assistant public defender with the 9th Judicial Circuit, and he failed to timely file his 2020 CE Form 1. He did eventually file his 2020 CE Form 1 on October 23rd, 2023. He was 782 days late, so he accrued the maximum fine of $1,500. The reason for appellant's late filing, according to him, is that he had a lack of notice. He states he did not reside at the address to which notice was sent, which was an address in Ocala, Florida. In support of his claim, he provided a lease agreement showing he lived in an apartment in Orlando from April of 2020 to April of 2021, and he also provided proof that he then purchased a home in Orlando where he lived from April 2021 onward. All notices were sent to Mr. King in 2021 to the Ocala address, which is not either of the Orlando addresses, at which he says he resided in 2020 and 2021. For this reason, we recommend we waive the fine because there is no evidence that he did receive notice, but we do have evidence that he was a resident in Orlando when notice was sent to Ocala. I'm happy to answer any questions.
Any questions from the commissioners? Okay. We'll accept a motion. All right, commissioners, work with me. Need a motion.
I make it, second.
Who made the motion? I'm sorry.
Fine.
I'll second it.
Thank you very much. Motion made by Commissioner Stewart, second by Mr. Figurs. All in favor?
Aye.
Aye. Any opposed? Motion passes. Item 10B, consideration of financial disclosure appeals. No hearing requested. Do I need to read all these names? Oh, I don't have to read all the names. That's great. Okay, we have 12 names. Item 10B are the appeals of automatic fines for failure to timely file their annual financial disclosure form where no hearing was requested by the appellants. Before none of the listed appellants requested to be heard, because none of the appellants listed requested to be heard, there is no oral presentation on the content of these appeals unless a member requests it. Are there any disclosures a member needs to be put on the record for any of these names?
I don't have a disclosure. But could we take up the first one separately?
Absolutely. So when we do make a motion, let's make a motion for number 2 through 12. Wait, how do we do that? We should make a motion to take up 2 through 12. Would that work? Okay. Okay. Are there any questions from the members on any of the appellants number 2 through 12? Okay. All right. Then I will take a motion, please, from one of you to accept number 2, the recommendations for number 2 through 12 on the list.
Move to approve the proposed final orders with respect to items 2 through 12.
Second.
Thank you. All in favor?
Aye.
Aye. Any opposed? Passes unanimously. And then we are going to now take a motion. I think we have to take a motion probably to.
Well, is there, so how, should we take presentation?
Okay.
on the
All right.
first
So
one?
we'll do a staff presentation first. And who would be doing that? Amelia, Naomi? Miss Naomi, if you could do a presentation on number 1, Caleb, all these names, Deacus? Not sure how to say that. And then we will open up for questions and discussion when she's finished.
Okay, so this is an appeal for Caleb Decius. He served as a member of the Planning and Zoning Board for the town of Lake Park. He's appealing his 2019 financial disclosure form, which was due in 2020. He cited to a couple different reasons in his appeal, but importantly, he never stated that he did not receive notice of his filing requirement. Rather, he stated that he did not understand his filing requirement. He also said that he is a musical artist and was dealing with the pressures of creating, and he was also battling depression over the loss of his son. While the commission, this is what the draft says right now, is that while the commission is sympathetic to his struggles, ultimately at the end of the day, dealing with the outside stressors of life is something that all filers have to manage while attending to their duties as public officers, and that does not constitute the type of unusual circumstance that Gray was describing earlier that would prevent someone from timely filing his or her appeal.
Thank you. Any questions from the commissioners?
One question I have, oh,
You're recognized.
thank you. One question I have is in the supporting documents, I don't know if this is something that we compile or something that is submitted by the appellant, I guess, I don't know if they're called the appellant, yes, the appellant. On page 9 of the materials, it looks like the signature the signature is Edmund Capitano, and it has some other information above that, I just don't know if that document is associated with Mr. Decius's Form 1, or if it was inadvertently included in the materials.
I'm seeing that. I'm not sure that was in the case folder, but we could always go back and check and make sure that is supposed to be in there, or if it's was inadvertently put in the folder.
Commissioner, what we could do is move this to the next meeting, check the original file and the information that was sent by the supervisor of elections to see if that was inadvertently included as a part of his form, and if so, get the corrected second page there so that you can have that.
Well, and I don't know that it matters substantively for our purposes, but and it's public, but if the record is either incomplete or inaccurate, I think that's something that should probably be fixed. And I didn't have any more questions, but maybe some discussion once that time comes.
Are there any more questions?
Are we continuing it, or?
Right now, we're asking questions, and then we'll have a discussion about how we want to handle it.
And thank you, Ms. Naomi, for the presentation.
Okay. Discussion.
So, I wanted to ask that question, but also, I think we just approved a recommended order in item number 7 for Lisa Fernandez based on personal hardship, in part because that appellant was dealing with caring for a sick child, and so for the sake of consistency, I would think that if that constituted unusual circumstances in that item, then grieving the loss of a child would also be unusual circumstances, separate and apart from the lack of notice, which is a different basis for waiving. So that I would be in favor of waiver in this situation to maintain consistency between those two decisions.
Any more comments or discussion?
No, I would second that.
No, I don't think that was a motion quite yet.
No,
Still,
the waiving.
still discussion.
Oh, was that
She didn't make an
I
official
just
motion.
want to clarify, because I can't hear down there. so-
Me neither. That-
Sorry.
I'll get that way closer.
Sorry. And I guess, I'm not sure procedurally if we're gonna, if the record, I guess maybe that's a question for y'all. If we wanted to make just like a technical correction to the packet, is that something that we would have to do next time, or could we make a decision on this and then it can be changed on the back end?
As part of your motion, you'll direct us to fix that, and we will make sure that the correct document is in there. If this was signed by, let's say, an agent of Mr. Decius, then
Right.
we'll confirm that.
Okay.
If this is a different person entirely, if this is a form that was supplied to us by the supervisor of election erroneously, we'll just take that document out, since it's not material to the matter. So we'll, one way or another, either we'll remove the document or we'll correct it. But you can move forward on this matter today without having that done right now.
Okay, thank you.
I would have to agree with Ms. Lucas. When you look at page 7, the box checked is letter E, unusual circumstances. And then part C, he explains the unusual circumstances. And that's where he says he's battling depression, lost his son. He says he's not being disrespectful. He just didn't have the capacity to do normal functions of life. Throughout here, it says he's moved to Los Angeles. He was on a zoning and planning board. I've served on those. It's not exactly a high-profile paid position of any sort. He was volunteering in some capacity in his community and hit hard times. And so I would tend to align with where Ms. Lucas is going and her thoughts on this. Anybody else have any discussion points?
I would move to waive the fine and to, if after review, make any necessary corrections to the record as stated by Steve earlier.
Second.
On this one, we've got a motion in 3 seconds. Great job, team. We are stepping up our game. Okay, we'll call it to vote. All in favor?
Aye.
Aye. Any opposed? Motion passes unanimously. Thank you, Ms. Lucas, for catching that rogue page, I think, and for bringing those circumstances to our attention. Item 11 is a consideration of final orders on final disclosure fines where there has been no timely appeal and no payment. Staff has put before us the consideration of default final orders where a reporting individual failed to make a timely appeal or failed to pay an automatic fine assessed for failure to timely file a Form 1. With your approval, a default order will be entered for each of the individuals on the list. Those in a position receiving public funds will be referred for salary withholding, and the others will be transmitted to the collection agency contracted by the Department of Financial Services for collection. Are there any questions from members? Is there a motion?
Move to adopt the default final order proposed.
Is there a second?
Second.
All in favor?
Aye.
Aye.
Any opposed? Motion passes. Item 12 on the agenda is seeking the Commission's approval to issue orders declaring fines as uncollectible because staff research conducted in an effort to collect the fines of those listed had indicated that these individuals have passed away. Are there any questions? Is there a motion?
Move to approve the proposed orders.
Second.
We have a motion and a second. All in favor?
Aye.
Aye.
Any opposed? Motion passes. Item 13, discussion of remote attendance to in-person commission meetings by members. This agenda item has been continued to the next commission meeting to afford members who were not present during the commission's previous discussion an opportunity to have input. Item 14 is reports. We have no chair report today. The executive director is up next, and I believe she does have a report.
I do. Thank you, Madam Chair. We do not have anything to update for the executive director report, but I did have some input from Commissioner Lyle, who indicated that, because the current status of the Loper v. Lucas federal court action is that the commission has been enjoined, and because our counsel believes that we will eventually prevail, that the commission should want this matter to move along. So the question is, what, if anything, can the commission do to get the matter moving and resolved so that the commission can once again enforce the laws that the legislature enacted? And so what can we do and what has been done? I asked Steve to look into this and report to the commission in case any members have any input or ideas on the matter. So with chair approval, I'd like to recognize Steve to talk about litigation.
Thank you, Madam Chair. Commissioner Lyle had asked us to look into the Loper versus Lucas, the status of the case, to see what could be done to get this matter moving, is the quote from his email. I looked into it. The matter was, we filed for summary judgment in the Loper versus Lucas case, and for those of you who are not familiar with the case, this is a case about the constitutionality of the statutory requirement that elected municipal officers and mayors file Form 6 instead of Form 1. We're currently under a temporary injunction so that would mean that those individuals now file Form 1 rather than the Form 6 that's in the statute. So that statutory change is not in effect right now. Our counsel, we're represented by the Office of the Attorney General. Mr. Bill Stafford is our attorney. And you met with him last November for on a video conference meeting, you'll recall, to discuss the status of the litigation. We filed for summary judgment in this matter to move the case along. The case is fully briefed as of November 8th, and so that's only 5 months ago is how old the case has been fully briefed for. I asked Bill Stafford what he would recommend here as far as if the commission's will was to do anything at all to quote unquote get the case moving along. And Bill said that it's his strong recommendation that we do nothing, and that the conventional wisdom is that if you ask the court for an order, you will get one that you won't like. Also, the chief judge of each district is required to prepare a list of each judge's outstanding motions that have been pending for more than 6 months, and this one is not among those because it's only 5 months old. So in the court's eyes, this is not even a languishing matter or anything like that. So it is our strong recommendation to do nothing right now and to just let the matter lie, and eventually the court will rule on our motion for summary judgment and the cross motion for summary judgment.
Any of the commissioners have questions for Steve on that?
Does any commissioner have a question? Otherwise, it's back to you, Ms. Stillman.
Okay, I will move right along with the legislative report. We're in the last weeks of session, potentially. There are a few bills that are still pending and with life, and so I'll briefly summarize those for you. Senate Bill 348, that was sponsored by Senator Gates, that's the Stolen Valor bill. That also included the salary withholding for complaint civil penalties. That has passed the Senate floor. The House companion, filed by Representative Maney, is on the second reading calendar. So hopefully that one is poised to make it through. The other commission recommendation that had a bill this session was the whistleblower protections bills, sponsored by Senator Gates and Representative Benaroche. Those bills were not heard in any committees this session. There is a Senate Bill 7002 that was the Committee on Environment and Natural Resources. It deals with water management districts. It's largely unrelated to the commission's work, but it does contain an addition to statute that would make water management district board members and their executive directors, as well as certain employees, subject to the expenditure ban, and authorize the commission to investigate lobbyists of water management districts and their principals if a complaint is filed alleging a prohibited expenditure was made. It's passed the Senate and is in messages in the House, and so we'll see where that leads. House Bill 1127, this was a new one that caught our eye. This week, there was language added that would allow state employees to receive incentives for participating in research or evaluation that was conducted by the Child Welfare Institute. The incentives, according to the language of the bill, would not be a violation of 112.313, nor would there be a reporting requirement if the incentives were accepted by a reporting individual who files a Form 1 or Form 6. They wouldn't have to report those regardless of the incentive amount. There are some bills at various stages of the process in the Senate, but at this time, none of the Senate bills contain that same language, so we'll be watching that. There is a Senate Bill 1726 and a House Bill 1321 that would have the University Board of Governors become Form 6 filers, so we're watching that. There are a number of bills that create entities that would have to file the Form 1. We're also following those for financial disclosure purposes. We have Senate Bill 822 and House Bill 443 that sets forth that the landlord of a charter school or their spouse or officer or director of an entity that is a landlord of a charter school is prohibited from being a member of the governing board of a charter school unless particular exemptions in the education law are met. The House version passed on the 24th, and it is in Senate messages. The Senate version is on special order calendar, I believe, for the 29th. Now we turn to House Bill 1049, Senate Bill 1838. These are the bills that make it a crime to threaten or tamper with or harass certain court officials in order to affect the outcome of an official investigation and other items. The Ethics Commission investigations are included in the definition of official investigations. The House bill has passed the floor and has now been substituted for the Senate bill in the Senate. So we'll keep an eye on that. House Bill 1445 and Senate Bill 1760 requires public officers and employees to be serving on boards to be U.S. citizens. There are other residency requirements. It also creates Section 112.31251, defining office for the purposes of the dual office holding prohibition. 112.31251. Yes, sir. Defining office for the purposes of the dual office holding prohibition. However, I'll note that dual office holding is not administered by the commission, but that definition would be contained in 112. There is also House Bill 5009. It creates an Office of Public Integrity, amongst other things. It passed the House floor. It affects how executive branch lobbyist audits might be done or administered. There is not a Senate companion, but the Senate Rules Committee took up the House bill and adopted a delete all amendment that deleted the language of 5009. It's now on the second reading calendar in the Senate, so we are paying attention there. That Office of Public Integrity would be able to accept complaints from House and Senate appropriations chairs, the Speaker, the President, and a few others that they could look into. They would then check with the commission to see if we were doing investigations, and would also give them the ability to refer investigations to the commission. We're watching that on a technical basis to sort of see what happens there. There are a number of public records bills we're following with exemptions. That does impact disclosure if people are confidential filers, if they request confidentiality and are permitted to have that public records exemption. That does affect our work, particularly with disclosure. So we are paying close attention there. There are rulemaking bills, nothing that significantly would impact us, but just things we would need to be careful to follow as we engage in rulemaking. And finally, the General Appropriations Act as it stands now, our appropriation for fiscal year 25-26 looks to be about 1.31% less than our approved budget for the current fiscal year, and about 7.5% less than what we sought. For the executive branch, the appropriation is less than 1% than the current appropriation, and about 4.5% less than what we sought. So it appears we're getting, if it remains as it is, a continuation budget. You'll recall that we had asked for funds to align with the Attorney General's office requests, a potential request for new positions within their ethics bureau. That accounts for most of the increase in the budget that we sought. After session, I'll be able to gather some additional information, adjust our operating budget before the beginning of the fiscal year to align with our appropriation, and that I am confident that between the appropriation and our existing carry forward, that we'll be able to meet the needs of our agency and carry out the mission. In my conversations with House and Senate administration in previous years, they do always want to make sure that the commission has sufficient funding to carry out its mission, and so I'm confident that we're going to have sufficient dollars to do that. We do have healthy dollars in carry forward. I will, of course, communicate with you if there's any specific needs that need to be addressed, or any special requests that we need to make, particularly if the Attorney General does seek to add additional positions. Those will be conversations that you all engage in at future meetings. And so that concludes my legislative report. We'll stay tuned to see what passes this session, and with the chair's approval, I'll move into e-filing.
Well, let's see if there's any questions or comments. That was a lot of information to digest.
Thank you for that update. That was a lot of work, and who knows what's going to happen. They're all moving around crazy up there. But I want to get back to my rant about hearsay and wanted to find out when we can proceed with the subject of hearsay that I think that this board has been terribly impacted by the definition that was put last year. And I just want to know where we are and what we need to do to move forward to address the hearsay component of the bill and language from last year.
Through the chair. Commissioner, you have raised this issue, I think, in this meeting before, and with me in conversations, with next session being a January session. They'll meet early, so we will put before you discussion of legislative recommendations for the, oh, dare I think about it, the 2026 legislative session, and we will put those before you to begin those discussions this summer so that we can get on that early. We will have information, for you related to the personal knowledge and information other than hearsay, as well as other items that have come up for you all to discuss and decide what your priorities might be as a body, and then we will pursue those as directed.
Any more questions, discussions on this? I'm a little bit irritated. This is the first year that I've been, I guess, engaged enough in our legislative agenda and following it and what's been happening. And we don't have, in an ideal world, we would present our legislative agenda and every legislator in the House and Senate would want to carry the bills and be on board and put them on hearings to at least be heard and debated and discussed. But I have enough insider knowledge, I feel like, up there by knowing enough of them that some of very important bills that we were supporting, never even made it to one committee for personal reasons or personal issues or whatever their reasonings are. And so I don't know that we have a structure here. We don't have a lobbyist per se. We don't pay somebody to go up there and lobby our bills, do we?
Steve and I are the designated lobbyists for the office because we, can't use public funds.
Yeah. Well, and I understand it, the look of the Ethics Commission hiring a lobbyist. I get that is, but I think maybe me being first and foremost, if I continue to be here, which we're not so clear on right now, but the future commission to take a much more, I guess, aggressive and active role early on to make sure that the bills that we want heard, that we're up there, not legal term of lobbying because we're not lobbyists, but that we're reaching out to legislators to carry these bills to make sure it takes active encouragement, communication, pressure, calls, and when you're finding that they're not even making it to committee, that we're calling the right people to make sure they make it to committee. I mean, the whistleblower one, for example, that it never even got heard anywhere. I don't think that's acceptable. And so, what do we need to do in the future to make sure that we're not ignored?
Absolutely, I think you're spot on with that. So that'll be a part of the legislative discussion you all can have as well.
Yeah, and so, just my remarks, I guess, maybe on my way out is I hope that the people in these future seats just take a more active role. And I guess that's going to have to come from you all to kind of guide them and pressure them and say, it's early on. Please call anyone you know up there. Please call this person. Here's the phone number. And so I think you're going to have to kind of spoon feed us because we always, we're not always engaged and we always don't know. Thank you.
Thank you.
Okay, your next report is your e-filing update.
Favorite part of the public session agenda where I talk about e-filing. Next week, we will be launching electronic disclosure fines in EFDMS. Commission staff has been actively testing the fines portion, as I reported last time. It's thankfully the automation of disclosure fines. This is the last piece of the e-filing puzzle, making the fine assessment, payment, appeal, and collection process much more efficient. Unlike with previous years, fines will occur in real time as forms are filed. Notifications will happen via email as opposed to regular mail or certified mail. So late filers will be able to see their fine details in the EFDMS system, which is not currently possible because we have to work in the old system. Filers will be able to pay fines in EFDMS. They can pay by credit card now, but not directly through our office. They'll be able to pay those almost immediately after filing a late report. So the most significant part of this is that we will no longer be working in two systems to administer the disclosure requirements that we have. The old system will go away. We will be working in one system. We won't have to worry about data migration and maintaining integrity of data. So we're very excited about that and very appreciative of the work that the IT team have done that. Of course, we're also gearing up for the upcoming filing season, including the coordinators finally finalizing their 24 list and adding updated email address information. We are making final preparations as a staff, including working with our call center partners. We'll be training them in the coming weeks. And we anticipate that filer notifications will be emailed to Form 1 and Form 6 filers on or about May 20th. And with that, I know you're looking forward to financial disclosure season, as are we. Be on the lookout for those notifications. And that concludes my e-filing report. I'm happy to answer any questions.
Any questions on the e-file? Anything else anybody wants to discuss before we adjourn? Take a motion for adjournment.
So move.
Second.
All in favor?
Aye.
Aye.
Motion, meeting adjourned.